This is episode 70 and the season 7 finale of Lawyered. I'm Hussein Panji. And on this week's episode, we are speaking with renowned legal professor and digital policy advocate Michael Geitz about all things related to internet law. First up, we're speaking about the controversial federal bill C-10, which would allow the government to regulate online broadcasters like TikTok and Netflix. We'll chat about what impact this bill would have on users who are creating their own content and the corresponding impacts on freedom of expression. Next, we'll talk about a different federal proposal to crack down on harmful content that's published on social media platforms. This potential bill will create a new structure that would remove things like terrorist content and non-consensual images, and there's numerous other legal issues that may arise as well. We'll also speak about a recent federal court of appeal decision that allowed for Canada's very first website blocking order, and this decision is prompting numerous questions about the roles of courts and ISPs to address copyright infringing material. And finally, in our Ask Me Anything segment, we'll speak about the right to be forgotten, net neutrality, and a bunch of other issues and questions submitted by members of our Patreon community. All that and a lot more is coming up in just a bit. This is Lawyered. Hello, everyone, and welcome to another episode of Lawyered. This is it. This is our season's finale of season number 7, believe it or not. During the season finales of years past, it's become a bit of a tradition for me to look back on how the year has gone, and I can see that this is the year where I've created the most podcast-related content, more than any other year. It's also been made a lot easier, like significantly easier, thanks to the support of our listeners and in particular our patrons. The contributions that you've made have made this show so much more informative and smooth and frequent, and I hope you find that the quality's been taken to a much higher level, compared to the pre-Patreon era, if you will. It's allowed me to explore some new opportunities, to assist other organizations as well, and use this podcast to leverage and advance our goal of decluttering the law. There's a lot more to go, certainly, but I'm very pleased with how the show is going, and I'm really fortunate for this excellent season with such a range of diverse guests as well. So in whatever way you're assisting, whether it's as a patron or as a listener or a guest or someone who just shares this show with other people, I want to say thanks from the bottom of my heart. This podcast started out and still is a labor of love, and it means so much that so many of you are on board with this important mission as well. The regular season is going to return, season 8, next spring, but in the meantime, I'm, as we speak, actually plugging away in some other bonus episodes that will air and they'll be released during the off season, so keep an eye out for those as well. I'm working on creating more of these bonus episodes, partly as a means of advancing this decluttering goal. And these are episodes that are less substantive, but more practical on the side of the law as well. On our last podcast episode, or I should say our most recently aired podcast episode, we had a really interesting interview with a lawyer named Amy Sandhu. And it was about the area known as ESG law. And that's an acronym for environmental, social, and governance law. And as I mentioned in that interview, I didn't know what that area was until I first got in contact with Amy. But it's a really unique intersection of ideas that is so timely in light of this growing social awareness of our community at large, and in particular the legal community. In that interview, we spoke about a few issues, including a new legal opinion that allocates corporate liability for issues related to climate change. There's also a new bill that would crack down on modern slavery, and also a new business structure that specifically directs corporate boards to improve their broader communities. Our guest for that episode is a lawyer, Amy Sandhu, who has dedicated a significant amount of her career to thinking and working on these specific areas within the law. And it absolutely comes through in the course of our discussion. So if you want to check out that episode about ESG law, you can find that on our episode page. It's episode number 69 on our page in our archive. you can also find this on the app and however else you're listening to the episode you are right now. Now, we are finishing our season strong, of course, with today's interview, and we'll be chatting about issues related to internet law. The time of this interview was interesting. It was fortuitous in the sense that right now, in the summer of 2021, there's a lot of live issues about the regulation of the internet. And in this interview you're going to hear, we're going to be speaking about a number of these, including some federal bills and proposals. Now, I should note that at the time of this recording of the segment that I'm speaking to you right now on, it's been announced that there's going to be a federal election in the fall of 2021. So many of you who are listening to this episode either in September of 2021 or afterwards, may be asking, okay, well, that bill and that proposal was part of a previous mandate, so who cares? But I should mention, and this comes across in our guest comments as well, that these same questions about regulation and the internet are going to remain for years to come, regardless of the status of these bills. So these questions about what role should governments play in upholding net neutrality, for example, and how do they reconcile freedom of expression? These are important issues that come across in this interview. So I'm sure it'll be practical with respect to these particular matters and for other issues down the line as well. Our guest for today's episode is a law professor, a blogger, author, thinker, advocate, and his name is virtually synonymous with this area of internet law. It was a huge honor to get to speak with him, and even greater honor to share this interview with you for a season finale. And so without any further delay, here's our interview with Dr. Michael Geis. Dr. Michael Geis is a law professor at the University of Ottawa, where he hosts the Canada Research Chair in Internet and E-commerce Law. He's the editor of numerous texts on copyright law, the editor of several monthly technology law publications, and the author of a popular blog on internet and intellectual property law issues. He's received numerous awards for his work, including the Canaries iWay Public Leadership Award for his contribution to the development of the internet in Canada, and was named as one of Canada's top 40 under 40 in the year 2003. And he's also obtained a Bachelor of Law degree from Oxford Hall Law School in Toronto, a Master's in Law degrees from Cambridge University in the UK and Columbia Law School in New York, and also has a Doctorate in Law from Columbia Law School. In 2010, Managing Intellectual Property named Michael as one of the 50 most influential people on intellectual property in the world. And Michael also has his own podcast, which he hosts, called Law Bites. And that's a podcast that explores digital policies and conversations with people who are studying the legal and policy challenges, set the rules, or are experts in the field. So, Michael, thanks for joining us on the show today.
Oh, thank you so much for having me.
I don't know if I mentioned this to you before the podcast, but this is actually our season finale for season 7. So we're looking forward to having this interview for a number of reasons, but I think will be a great way to cap off our season as well. We have a number of really exciting issues to speak about regarding internet law, and you're easily the most qualified person to speak about these. The first one is about Bill C-10. And as many of our listeners know, one of the most controversial areas of internet law has been the proposed federal amendments to the Broadcasting Act known as Bill C-10. Now, amongst other things, this bill seeks to permit the CRTC to regulate online broadcasters like TikTok and Netflix in a similar manner that it regulates traditional broadcasters, with an emphasis on promoting Canadian content. Now, this bill has had a tumultuous route through the legislative process, and this bill is also sparking important discussions about freedom of expression, Canadian culture, and the role of regulation. So, Michael, I know this is an area that you are writing and I've spoken about on numerous occasions. And as I mentioned, a significant part of this bill involves Canadian content. So for people who are unfamiliar, I was hoping you can just first start out by telling us what exactly Bill C-10 is proposing to change in terms of Canadian content in the digital space.
Sure. So it's a good place to start. And I think the starting point, at least for the government, was that this was about trying to bring in some of those large internet streaming services, you mentioned a few of them, the TikToks and Netflix of the world, into the Canadian broadcasting system. And their argument was that they had an unfair advantage and they wanted to ensure that Canadian broadcasting law applied to some of these same online streaming services. Now, at the heart of that is, I think, fundamentally about making those companies pay, so that they want to ensure that those companies pay into a fund that can then be used to go ahead and fund Canadian content. That proved to be, I think, a little bit pretty uncontroversial, even though, as I say, I think there are arguments against it. But things really took off when the government effectively expanded the scope of the legislation to go well beyond just the Netflixes of the world. The government's view was basically any audiovisual service anywhere in the world with some amount of Canadian subscribers or Canadian connection could in theory be subject to CRTC regulation. So it wasn't just Netflix or Disney or Amazon Prime. It was niche streaming services from countries around the world. It was even news websites that have audio or video. An internal government document suggested that it included podcasting services. In fact, a podcast like this would in theory be subject to the regulation as well. So it was very, very broad, and it effectively left to the CRTC to decide whether there would be thresholds and what the cutoffs might be, and then depending on whether you were above or below the threshold, what some of your financial responsibilities or requirements would be.
So for transparency, we're recording this interview in early to mid-August, but I know that there's been some changes, at least one substantial change since the bill was introduced. Can you tell us a bit about what's changing and what people are really talking about now?
Yeah, so I mean that's really how the bill became controversial with a change that the government made. And I think that I should note that as we record this, the bill has passed the House of Commons and is currently in the Senate. So I don't expect there will be no further changes in the House at this stage. If there is an election called, the bill will die and won't go forward. So it's possible people are listening to this in the midst of an election campaign and the bill will have died. In any event, back in the spring, late April, the government removed one of the safeguards that had put into place from the very beginning. And so it said, well, we're going after the Netflixes of the world, but we are not going to target individuals here. User-generated content of the sort of that people post at sites like TikTok or Instagram or YouTube, and government in Bill C-10 excluded both those individuals from being regulated. They said they wouldn't treat them like a broadcaster, so they wouldn't have to show up before the CRTC in the same kind of way, and that they would also exclude their content from being regulated in the same way that a broadcaster's programs might be subject to regulation as a program. In mid-April, the government itself made the decision to remove one of those two safeguards, in particular the one around content. And so while they kept in the safeguard that said a user, an individual, won't have to appear before the CRTC, they presumably didn't want millions of TikTok users showing up in Gatineau for these kinds of hearings.
That would make a good video if they did.
It certainly would. It did come to the conclusion, though, or it did take the approach that their content would be subject to regulation like any other program. At least that was initially the approach they took. And that's unquestionably, I think, what sparked much of the concern because, for an entire generation of Canadians who are on TikTok, Instagram, and YouTube, that's just basic expression in the same way that for people in my generation, it might have been blog posts or emails. A prior generation might have been faxes or letters. We'd never dream of saying that a broadcast regulator ought to regulate that kind of expression. But here we had the government adopting an approach that said, well, we are going to regulate, or we have the power to regulate that kind of speech if it's an audiovisual format, effectively for millions of Canadians.
So before we get into the legal issues, what would that look like practically? So if this bill passed in this form, and then you are publishing blogs on YouTube or dances on TikTok, what does this actually mean for the users in terms of how would they be regulated?
Their core regulation, or one of their core regulations, was what they called discoverability. The idea that they wanted to enhance the ability for people to find Canadian content. Now, I think it's worth noting that on services like Netflix, And their algorithm is very good at finding what people want to watch. If people want to watch Canadian content, it is going to provide them with Canadian content because they're in the habit of trying to ensure that subscribers find stuff they want to watch so they remain subscribers. But even if we park that to the side, the idea that we would do that in a user-generated content world for something like YouTube videos or TikToks, I mean, that simply isn't done by any other country in the world. And it's hard to even know how you would go about doing it. But the government said, this is what we want to see the regulator do. And in effect, it would be prioritizing or deprioritizing some content over others. And so the fear for many was that if you are part of a specialized class, let's say sort of some that have been actively involved in this lobbying, you might find your content prioritized on something like YouTube. But if you're even a Canadian creator who's done very, very well on YouTube, but you might not be identified as Canadian, you might not be part of that kind of regulatory world, in effect, your content would be deprioritized. And having a government regulator making those kinds of decisions, I think, struck many as highly problematic.
And I know that a lot of people, I think yourself included, are suggesting that there's a potential charter breach in terms of freedom of expression. Can you tell us a bit about how that plays out?
Yeah, I think there is a charter concern. I think that what it really does is open the door to widespread speech regulation. Now, we can have a debate as to whether or not prioritizing or deprioritizing certain kinds of speech is sufficient from a speech regulation perspective to invoke the charter, and we can get into questions as to whether or not it ought to be saved or not. The government, in my view, didn't even really engage in that second stage analysis, though. They kind of just sort of dismissed this and I think left a lot of people really unsatisfied. It's just incredibly difficult to know what would even be captured as a starting point. Candidly, I don't even know where you're located as we have this conversation.
I'm in Toronto.
Okay, so you happen to be in Toronto right now. If you were doing this, and I've recorded some of my own podcasts sometimes when I'm traveling, if I'm in the United States at that point in time, is it still Canadian? If I interview someone who isn't Canadian, I've had many guests from around the world, are those Canadian? Does that qualify? Under what circumstances do I have to start identifying this content as Canadian? Is someone going to rule on whether it meets Canadian content? It is such there's such a myriad of complexity associated with this. From my perspective, I don't think there's any doubt that it involves speech regulation. I think you can have a fair debate as to whether or not it is justifiable and therefore saved. But the starting point surely is if you've got a broadcast regulator saying that requiring large platforms to deprioritize certain content by prioritizing other content, I would argue that our expression rights include the right to be heard in this format without governments interfering via, in this case, the regulator. And so then you need a better analysis as to whether or not it's saved. And the government never really engaged, I think, in that kind of discussion.
In the summer of 2021, shortly before this recording, the federal government circulated a proposed framework that would seek to crack down on harmful content that's posted on online platforms such as Instagram and YouTube. And this potential structure would require online platforms to remove harmful content, such as child pornography and terrorist content. And while these proposals are at a very early stage, they would also include a new appeals process and investigative powers. And many commentators are questioning about the practical effectiveness and the legal challenges that may ensue. So, Michael, these proposals would impose these obligations on what are called online communication service providers with respect to online harm. So could you start by telling us a bit more detail about what these platforms would be required to do based on the information that's been provided?
The government seems to have reached the conclusion, and it's consistent with some of the Bill C-10 issues, that views technology companies, these large internet players, as really being significant sources of harm that are in need of a significant amount of additional regulation. They themselves would be generally happy to see it removed. I think most are of the view that they could and should be doing more, and the government is now determined to require them to do so. And so there's a number of different requirements should this proposal be introduced as legislation and ultimately turned into law. One thing would be a requirement to remove content that's identified as harmful, and government is sticking for the moment specifically to a number of kinds of content that are viewed as illegal content. If flagged by a user, it has to be addressed within 24 hours, generally speaking, taken down within 24 hours. There are some serious concerns about whether or not there will be effective due process in those circumstances. I mean, the government is establishing a framework that really incentivizes the removal of content. And so it is likely that these platforms will simply remove content where this comes up within the 24-hour period, lest they face significant liability. And the effect of that will be to remove a lot of content that is, in all likelihood, legitimate, perfectly legal content, but they're going to err on the side of removal based solely on an allegation, given the liability possibilities.
The way that the proposal is drafted, I think there's 5 main areas that are identified. And so, by my understanding, they are child pornography, terrorist content, incitements to violence, hate speech, and the non-consensual sharing of intimate images on the internet. You mentioned that there might be a concern that these providers may be overly broad, going maybe beyond the scope of these 5 categories. Can you tell us a bit about why you expect that might happen?
Sure, of course. So, I mean, let's start by saying that obviously no one is in favor of this kind of content. And I think there's frankly a compelling argument that if this form of speech is already regulated, we already are in a position where there are tools to address it. Establishing this extensive new framework in order to deal with speech that is already the subject of regulation, I think is worth questioning. As for why it is likely that this will be overbroad, I think it's simply the case that if this requires nothing more than an allegation from a user, they flag some content and they say, "Hey, I believe this is hateful content." I mean, that's an area that is just rife with edge cases, that there really are at the edges, lots of other speech that we may find distasteful, that we don't like, but whether or not it rises to the level of illegality is a different question. But once you establish a framework where there isn't built-in due process, effective review to ensure that it is only the unlawful content that's removed, and you create significant liability for the platforms if they fail to effectively address something, what you're doing is really a recipe for removing content, even that edge-cased content that may be perfectly lawful, but will be removed anyway. And one of my fears is that the very groups that we are seeking to protect, the ones that are often themselves the subject of online hate, will be the subject of these kinds of complaints. And so the same purveyors of this hateful content will file complaints against some of these groups. And the incentive, again, will be simply to remove, because it's just that really reduces your risk or your liability. And that's really where the incentives are. We've seen this play out in other jurisdictions, and that's precisely how it unfolds.
So another aspect of this that's getting a lot of attention is in terms of the enforcement inspection approaches that are being introduced through this proposal. I know that some people, maybe yourself, have some charter concerns about that. Can you tell us a bit about what these inspection enforcement mechanisms are, and then what charter issues might be triggered?
Well, there are appellate processes, both with the Digital Safety Commissioner, and then there is an additional tribunal that will make further decisions as to whether or not something is lawful or not. Well, sure. I mean, this is an exceptionally broad inspection power, one in which, and it involves, again, this Digital Safety Commissioner. I mean, as part of their investigative powers, it includes within the bill an inspection power that extends really to anyone, not just these online service providers. And so if there are reasonable grounds to believe that there may be information somewhere else, there is that inspection power, and it can relate to anything like software or algorithms or really anything that's relevant to an investigation. And that I think immediately invokes some of the kinds of concerns we have under the Charter when it comes to search powers and whether or not these searches are lawful or not. There's the possibility of hearings in secret as well. So this refers specifically to the Digital Recourse Council of Canada. This is this new tribunal that the public could file complaints with and would have the power to rule on content. So essentially, it's a content czar that would make decisions as to whether or not content should come down or not. And the bill itself states that some of their hearings can be conducted in secret under certain circumstances.
Given the nature of online speech, I think some people may think that there is a need for a different set of enforcement rules for speech on the internet and speech that's not on the internet, given the way that information travels.
If we are talking about illegal speech in Canada, then that speech is already, by definition, subject to regulation. So this is largely an enforcement question. How do you deal effectively with speech that we've already identified in this way? And I think it is fair to say that the platforms need to play a role here. Now, there are limits in terms of what the platforms can be held liable for, even including within our trade agreements that create some limitations in that regard. There are limits on the extent to which there is responsibility there. I think that they clearly have a role to play. But hateful speech is hateful speech, and it is the person that is behind that speech, if we're talking about hate, or if we could be talking about any of the specific forms of speech. The child pornographer, really, we must at the same time be laser focused on the purveyors of that content and ensure that our laws can be effective in dealing with those. That, in other words, you don't solve the issue if the only thing you do is say that it is the platforms themselves that have to step up. I think these companies could be far more open and transparent, far more forthcoming about how they handle hate speech, how these complaints are addressed or these flags are addressed. I mean, many times people may flag something and it goes into a bit of a black hole and you just don't know what's happened. I don't think that's good enough. I think there is a responsibility, or there ought to be a responsibility, backed by real liability for failing to be transparent. I also think that these same companies often feel very inconsistent in terms of how they apply those rules. And so sometimes content comes down, sometimes it doesn't, sometimes it seems to be applied to some individuals differently from how it's applied to other individuals. And, if these companies are going to play such an important role, and let's recognize that they do, there's got to be consistency in application. And there has to be liability where there is a failure to be consistent and uphold your own policies. That where you have companies saying that, our community policy is, or our user policy is, that we will not permit this kind of speech, and it will be taken down, and we will, remove the user from further postings. If that's your commitment, you've got to live up to it. And if you fail to live up to it, then you ought to be held liable for having failed to do so. And to me, those are, specific rules targeting those kinds of platforms that we don't have right now, but we should.
In May of 2021, the Federal Court of Appeal issued a landmark ruling that affirmed the very first website blocking order in Canadian history. And this case discussed the jurisdiction, of course, to require third-party ISPs to block access for websites that publish copyright-infringing material. And in addition to the obvious copyright issues, this case also introduces new questions about the federal jurisdiction in the internet space and its relationship to net neutrality. So, Michael, before we get to the case, I was wondering you can just explain to us what is a site blocking order and what does that mean?
Right. So this issue of site blocking refers to the possibility of having a court order internet providers to block access to a particular website. So long as the order is applied to the various very large providers, they have the effect of covering most Canadians. And the effect would be, once put into place, is that these internet service providers would be required to install equipment and then use that equipment to, on a best efforts basis, block access to a particular website. And so the users would be unable to see particular content or access that site. We've had various rights holders, so copyright owners, pushing for site blocking for some time, arguing that particularly for streaming media, there are unauthorized websites that will stream on an unauthorized basis content. It might be TV shows, might be sporting events, and other kinds of content. And many of those entities that hold the rights to streaming that same content within Canada have argued that this is hurting them, and they would like to see the websites block access to those services, arguing that there are Canadians who are seeking access to those sites. They want to be able to gain access to it.
So the name of the case, and we'll have a link in our show notes, it's called Tech Savvy Solutions, Inc. And Bell Media, Inc. Hoping to give us a sense of what were the facts that led to this matter getting all the way up to the Federal Court of Appeal.
Right. Well, you simply had a website that was identified called Gold TV that was streaming from a number of different domain names, goldtv.biz or goldtv.ca. And the argument was they were operating unauthorized subscription services. So people would often pay for these services to gain access to various kinds of content that was streamed. The argument was that Gold TV did not have the rights to sell subscriptions to this content. And so what the plaintiffs were looking for was a court order to block access to Gold TV.
Tech Savvy was involved trying to, to challenge this order. Is that right?
Right. Well, Tech Savvy was one of the ISPs that was served with this claim. It was really looking for an interlocutory injunction, so it was looking for just on an immediate basis to have this order in place. The order targeted a number of other ISPs, so Bell and Rogers and TELUS and Shaw, and some of the very large ones that are out there, Videotron. Some of those same players are very large owners of the same content, though. So they did not oppose this, but Tech Savvy did. And, they had real concerns about the implications of a site blocking order, concerns about what sort of standard would or should be used by the court before a site blocking order is issued, questions about what this would mean for everything from net neutrality to freedom of expression. And so they challenged both at the trial level and later at the Federal Court of Appeal.
So when it got to the Court of Appeal, how did the court find?
Right. So at the trial level, the court was willing to issue the order. That order was upheld by the Federal Court of Appeal, and so they essentially found that there was not judicial error by the trial judge in this case. There were a number of issues that Tech Savvy raised that the Court of Appeal sort of seemed to suggest that, well, yeah, we understand your concern, but we don't think that it rises to the level of judicial error. So, Tech Savvy said, the trial judge should have engaged in a more detailed analysis around certain of the issues, some of the implications, for example, something like overblocking, which experience around the world suggests that once you start moving towards site blocking, it is almost inevitable that you will overblock. And so in an effort to target a particular site, you are likely to find there's a large number of other sites that are blocked in the process. And the Court of Appeal said, well, yeah, it's true that there could have been more discussion and more analysis of the issue, but this and others did not rise to the level of judicial error, and so they upheld the lower court's decision.
A big part of the appellate decision was about jurisdiction and whether, courts even have the ability to grant these kinds of orders. Can you tell us a bit more about how that specific question was resolved?
Yeah. So the question of jurisdiction often comes up in an internet context, and it did here as well. The federal courts relied on the Supreme Court decision in Equistec, which is a case that involved BC-based company called Equistec and Google. And the question in that case was whether or not a BC court could issue an order seeking the removal of certain results from the Google search index. Now, what made the case interesting and an important one, and why there was an argument that this applied here, was that the order that Equistec sought in that case was not limited just to Canadian users of Google. In other words, it wasn't limited just to the search index that Canadians would be able to access, but the order would apply to Google on a global basis. The idea was they wanted it removed from the global search index and therefore would affect all users everywhere. And so that's a really broad approach. The Supreme Court was still willing to do it, though. They upheld the order. They argued if there were speech implications, the court could adjust the order effectively. They argued if there was competing orders. So, for example, if a U.S. court came to the conclusion that the Canadian order was overbroad from a speech perspective, given their protections of speech, that a Canadian court could seek to adjust the order. But as a starting point, it found that such an order was acceptable. And in this case, TechSavvy, for example, argued that Equistec involved things like trademarks and trade secrets, not copyright, and so that there were differences between the two, arguing that copyright is a creation of statute, and so if the government really intended for this kind of blocking power in this broad order to be available, it should have made it available in the Copyright Act. It hasn't, and so the argument was that it shouldn't apply here. But the Federal Court of Appeal rejected that argument, as well as a couple of others, in terms of saying that it had the jurisdictional power to issue this kind of order.
So by all accounts, the fact that this is the first website blocking order seems significant. What do you think? Do you think that this case will have an impact on online service providers and copyright holders down the line?
Yeah, it's already having an impact, and so we have already seen new cases launched. A recent one, for example, involves streaming of NHL games, and the rights holders, in this case Rogers is the large rights holder, is becoming increasingly aggressive in light of this decision. And so they want what's known now as a dynamic blocking order, knowing that some of these streaming services' IP addresses change, and sometimes change very rapidly. They want the ability to have an order that will change with it. And so rather than, as in some cases, saying, this is the domain, I'd like to see it blocked, they want something that can adapt as the domain itself or as the IP address itself changes. And so the implications become even more significant. Suddenly now it's a living blocking order that kind of travels as the sites themselves may travel.
For the last time this season, we're going to do our Ask Man Things segment, this time with Michael Geitz. As listeners of our show will know, one of the bonus awards for members of our Patreon crowdfunding community is the opportunity to submit questions that they want to hear our podcast guests answer on the show. These can be questions about anything within reason, within the guest area of expertise, as long as they're not asking for legal advice. We do a call for these questions about a week before the recording. So if you want to learn more about this and how you can become a patron and submit your own questions, you can find out more on the website, which is LawyeredPodcast.com/patron. So Michael, unsurprisingly, we got a number of questions for this specific episode. And the first one that's been submitted is about the right to be forgotten. There's been a number of articles and, publications that have come up recently. So the question is, how does the right to forgotten apply in the Canadian context? And maybe we can start by telling us, what is this right to be forgotten?
Yeah, so the right to be forgotten, which I think in some ways probably better framed or thought of as a right to be de-indexed, speaks specifically to content that is accurate but still causes some amount of harm. So, the internet, as they say, never forgets. Something that gets posted today will live on for years or decades, and stuff that was posted 20 years ago is still oftentimes readily available or is available online from different kinds of sources. And some of that content may have been accurate, may remain accurate, but may be harmful to individuals. So, for example, something that was embarrassing or something that raised some real issues that spoke to the person's character at the time, but isn't necessarily true anymore, proponents of that would argue, there should be the ability to have this kind of content removed under certain circumstances from the Google search index. So it is not removed from the internet itself. The party that posts it may say, no, this was lawful, legal, there's nothing wrong with the content itself. And they don't want to remove it. But if you can get Google to remove it from the search index, it would have the ability, or might have the ability, at least reduce the likelihood people are going to find it. It's not an easy question. We've seen this play out in Europe, and in Europe, it's been in place for some time now. And some content, there are standards that have been established. Google gets many, many requests in the hundreds. They've received in hundreds of thousands of requests. There's some content that they say, no, we think content is fine. There's other content that they immediately recognize the harm and are willing to remove from their index. And then there's sort of the third bucket that's a really tough call, and it will sometimes be escalated within the company to make decisions, and sometimes can escalate to adjudicators within data protection commissioners who may ultimately be asked to make the call as well. We've seen in Canada some litigation that has sought to argue that current Canadian privacy law effectively already has some of these powers in place. The question is whether or not that will be effective or not, and further, whether or not the Canadian government ought to go further by creating a specific right to be forgotten power within Canadian law.
The next question is, in 2021, the federal government introduced Bill C-36, which, amongst other things, would make it a discriminatory practice to communicate hate speech via the internet, where the speech would likely, quote, foment detestation or vilification of individuals on the basis of a prohibited ground of discrimination. So the question is, if passed, how effective do you think this bill would be at addressing hate speech on the internet?
So this is a bill that the government introduced quite literally in the very last hour of the House of Commons before it took a break for the summer. I think the zero expectation was going to be passed. And I think there were many anti-hate groups that were actually pretty disappointed that the government took so long to introduce this and was kind of using this for political purposes as opposed to really trying to address the problem. Now, this is linked in many ways to our earlier discussion around online harms. And in some ways, I think that they quite clearly operate together. This is the criminal side of online hate, and the online harms is the part that deals with the platforms themselves. As for the question is whether this will be effective or not, there are two main elements to C-36. There's the criminal provision side. There's a second side that deals with human rights commissions and the ability to file complaints. On the criminal side, I think there's the possibility that where speech rises to that level, there is the possibility that it will be effective. I think it is worth noting, of course, though, that that is a high threshold. It's a tough threshold to get a Crown prosecutor to bring a case under the criminal code for speech, but it's not unheard of. We obviously have had some in Canada. It is based on standards that we have had from prior cases. And so this provides some ability to try to deal with that. The Human Rights Commission side, which when it was previously around was mired often in controversy, I have somewhat less confidence in. It seems to me that is open to potential abuse. There's been no indication that there are resources at the Human Rights Commission to deal with what could be just a massive number of complaints. And so, I think that where this sort of speech rises to the level of true criminal speech, we need to ensure that there are effective tools to deal with this. I'm not as convinced at this stage that the Human Rights Commission approach, based on our prior experience, will be as effective.
So the next question is a more general question. So how do countries practically assert legal jurisdiction over the internet, given that the internet is inherently global?
Right. I mean, it's a fun question in part because if I think back on my career as a legal academic. One of the very first papers I wrote that got a little bit of attention was exactly on this issue, roughly about 20 years ago. So
maybe I wonder if the answer may have changed in the last 20 years.
I don't think it really has. My point was really that it has been these same questions that have been a challenge, really, I think, from the very beginning of sort of the commercialization of the internet and the widespread use of the internet. And I think the answer is that no individual country could or should rule the internet for everyone, but that individual countries should surely have the power to establish their own rules domestically. Now, and I do think that, we need to recognize that just because you have the power to enact certain rules doesn't mean that those are the rules you should be enacting, and that we at least need, I think, to go in with our eyes wide open around some of these choices. There will be, even along the way, some challenges in enforcing, to be sure, and sometimes those enforcement costs and that enforcement approach may itself raise significant issues. So none of this is to say that the internet is this kind of no-law land. It isn't. But at the same time, we ought to recognize that I don't think we want the internet to be the most regulated space in the world where everybody's laws apply to everyone all the time, right? We were speaking earlier about, the ability for Canada coming out of, say, the Equistec case to, say that, yeah, we should be able to order Google to remove content from its search database on a global basis. I understand why someone might say that from a Canadian perspective, but would we be as comfortable if that was Iran or Saudi Arabia or China or Russia, and one of its courts was making the same decision and saying it should have the power to decide for Canadians what they can and can't see? I suspect for many the answer would be, well, of course not. Well, there isn't much of a difference if you say your court gets to decide for everybody from any other court. And so that kind of the need for some amount of almost, I think, judicial humility as well as regulatory humility to know that, just because you could say, well, we think that we ought to have the power and establish these kinds of regulations doesn't mean in every circumstance that you ought to exercise those powers, because there are big implications.
One of the issues that we've not really spoken about on today's show has been about net neutrality. But this question is about how have courts addressed the concept of net neutrality in their jurisprudence?
Sure. So the idea, just as a start of net neutrality, is the idea that internet providers will treat content on an equal, non-discriminated basis, regardless of the type of content, its source, what application is being used. It's in part at least a competition-related concern, one that stems from a concern that the large internet providers, particularly true in Canada, are very large, are very big. They also has, as we were talking earlier, these large content arms. They may well have incentives to favor their own content over others. For example, one can well imagine Bell, for example, which owns CTV and owns a lot of radio stations. They might be interested in prioritizing their own streaming content over Netflix or even over podcasts, because they'd rather people listen to their radio programs or the podcasts from their radio programs as opposed to independently created content. And so net neutrality is designed to stop that from happening. We actually haven't seen a lot of court cases on this issue, but we certainly have seen a number of cases come before the regulator, come before the CRTC, and it's the CRTC that really established this framework. It's a framework that I think many have taken the position is a good one. It remains to be seen how the government treats some of those issues. They have in the past been pretty steadfast in indicating that they are supportive of net neutrality, but certainly as part of the discussion on C10, the broadcast bill, we did see the Heritage Minister, I think rather oddly, either misunderstand net neutrality or simply shift away from the longstanding policy by sort of taking a position that those that were opposed to the bill were kind of these people who just are in favor of net neutrality, as if that's a bad thing.
And is net neutrality a principle that has any legal weight? Does the CRTC have any, guidance that recognize that this is a principle that we will consider in our decisions? Right.
Well, it is baked into the law as a starting point. So the CRTC didn't sort of make up net neutrality out of kind of whole cloth. It used the existing Telecommunications Act and some of the provisions in there to interpret those provisions and to create a net neutrality framework, which it has called the Internet Traffic Management Practices, or ITMPs. So we've seen that. At a political level, we did have a specific motion that dealt with net neutrality that was approved by the House of Commons a couple of years ago. So, the various political parties are on record as being supportive of net neutrality. But there have been fewer cases that have challenged this, in part because those cases tend to go to the CRTC as opposed to the courts themselves.
On today's show, we've talked about a number of current issues within internet law space. The question is, what do you foresee as some of the upcoming legal issues that internet lawyers may be dealing with within the next couple of years?
Right. Well, I think we've been talking about some of them because the issues that we've been talking about, several of them are still at a fairly early stage, and they're as part of legislative proposals as opposed to legislation. And so even if we have an election, these issues are not going to go away. The bill is not going to go away. And regardless of the government that's elected, we are going to be grappling with these kinds of questions. So, for example, platform liability questions, the role and responsibility of the large internet companies is an issue that is certainly going to be here for a while. And I think, to me, at the heart of many of these issues really is about data, the data that's collected and gained by these large companies, how they use it, what recourse people have, where it gets used. And, those issues, whether under our current rules or under new updated rules that may be introduced at the federal level. There is a bill, C-11, that will also die if there's an election call, but it will be looking at some of these. It seeks to update and address some of these questions. So, too, we've had a number of provinces introduce new legislation. Either way, it seems to me that lawyers are going to be grappling with those questions for the foreseeable future. Data really is such a critical part of the equation for all of this. And to pick a third, especially for lawyers that, let's say, are engaged more in commercial practice, e-commerce, internet-related questions are just are increasingly indivisible from business. I mean, the reality is that success is rarely now confined to an offline service, and so those questions around enforceability of contracts and global issues seems to me are going to be around for quite a while as more and more businesses take their businesses online, begin to attract a global customer base, and then have questions about how they ensure that they are compliant with the rules, or how they ensure that what they are doing is enforceable so that the business can run in an effective manner.
All right. So, Michael, I want to thank you so much for taking the time to speak to us about these internet law issues. I think literally everybody deals with these issues every day, whether they recognize it or not. So it's helpful to get a sense of what these issues were. And, although some of these are based on legislative bills and proposals, which may fall at the election time, as you mentioned recently, these principles will remain, constant regardless. So it's a real treat to have you on the show to help us cap off our season, and we look forward to staying in touch in the future.
Oh, great. Thank you so much again for having me.
And that's it. That's a wrap on this episode and this season of Lawyered. Thank you for listening. Our guest for this episode was Michael Geis. You can learn more about him and all the interesting that he does on his very active website and blog, which is michaelgeis.ca. Michael also hosts his own podcast called Law Bites, which focuses on digital policies and the law. And for more about today's show and links to all the cases and bills and proposals that we spoke about today, you can find those on our website, which is LawyeredPodcast.com. I want to give a special shout out to all of our generous patrons who've contributed both their energy and their funds to make this show happen over the last year. So thanks so much to Abbas Qasim, Andrew Monkhouse, Brian Osler, Candace Cooper, Carolyn Poutianian, Connor Coles, Don Bourgeois, Ethan Marks, Glenn Paquin, Hudson Panju, Jeff Langweir, Karen Gottfried, Lisa DeMarco, Muhammad Abbas Marshi, Mark Aspar, Mike Rusick, Michelle Corson, Mohamed Moladina, Mohan Pandit, Monar Chatu, Peter Zhakowski, Rebecca Finley-Shadlowski, Riazan Patul Panju, Saad Beg, Sajad Infrana Kosmali, Samantha Chen, Stacey Hoshin, Stephen Lockwood, Sujoy Chatterjee, Trevin David, Urj Zaman, Basilis Tianos, and Rebecca McBean, and everybody else who's been so supportive of the show over the last year. Thanks for making this show happen. Thanks for continuing to keep this show on the air. I also want to give a shout out to our sound editor, Solomon Kraus-Imla, who's been an absolute gem to work with over the last year or so, doing our freelance audio work, and has been so responsive and helpful in making this show's quality as high as it has been. A theme has been provided by Ben Spursky. That's still remaining as consistent as it was before. And the website's been maintained by Steve DeMello, and Steve's been doing an excellent job at keeping this website both current and adaptive to changes that we're making to make this show more responsive, more accessible to everyone else as well. And finally, please be advised that while this show is aimed to be helpful and informative, that it is not intended to be legal advice. And if you do want legal advice, please reach out to our lawyer directly to help you with your particular situation. And with that, we will see you next season. And until then, keep it legal.